Good to be back. I had some busy month of conflicts over the last month, so I know have not been here to host in about a month. So it is good to be back. So thanks everyone for being here. I see people are still logging in. The numbers are going up. So with that, we'll just get started. I'll show you our agenda for today. We have 3 presenters today. And first we'll head to Buffalo with our associate in the business department in Buffalo, David Bergio. We'll talk about service and emotional support animals in a few different contexts. Then we'll have Laura Harshbarger with a very, very timely update with the implementation of New York State paid breast milk expression law. The updates to that law take effect tomorrow. And as of a week ago, when I was doing a presentation, we still didn't have a lot of our questions answered. The guidance did just come out within the past day or so. And so Laura will be here to give us all that fresh new information to be ready for tomorrow. Finally, Subha Viswanathan is here. Subha is here frequently to talk about various wage and hour considerations. He's going to give us a refresher on travel time considerations in the wage and hour context. So with that, we'll get started with our first topic today with David. David, welcome. Thanks for being here, and take it away.
Thank you so much. Pleasure to be back, guys. So today I'm going to give you a little broad overview on service and emotional support animals in business from the customer and employee standpoints. Next slide, please. So just some definitions. First, we're going to make that distinction between the service animal and the emotional support animal. A service animal, the key here is that it's a dog specifically that is trained to perform specific work or tasks that's going to be related to a person's disability, while an emotional support animal is just any animal that provides emotional support that kind of alleviates some of those symptoms of potentially a mental disability. These animals don't have to have specific training, and they're also known under the FHA as assistance animals. And again, that distinction is that the service animal is going to be trained to perform a specific task. We're also going to talk about Title III of the American with Disabilities Act, the ADA, which applies to public accommodations and commercial facilities. And in that title, only dogs are considered, and in limited circumstances, miniature horses, believe it or not, as service animals. And then Title I of the ADA, which applies to employers, that's going to be more broad, and it can be any animal that can be requested for reasonable accommodations. Next slide. So first of all, we're going to talk about the customer or patron point of view. Obviously, this is a little more broad in application, but under Title III, businesses and nonprofit organizations, really anybody that serves the public, must generally allow service animals specifically to accompany people with disabilities in all public areas of the facility. And there's a couple questions that you as the business owner or employees can ask. And you can make these legal inquiries in 2 ways. So you can ask, is it required because of the disability? And what work or task has been trained to perform to help you with that disability? But you got to be careful and walk the thin line. You can't ask about the specific disability, like what is the disability? There's no required medical documentation for them to have, no license or ID card, and you're also not allowed to ask for demonstrations. Next slide. So, you ask these questions. Let's say, we have valid answers here. Both of the questions are answered in the affirmative. Can you still deny service? The answer is yes. It's in limited circumstances. First and foremost, it has to be identified as a service animal by answering those legal inquiries. There's no accommodation for support animals. So if they identify it as such, then you as the business owner or the employee in question has the right to, ask them to leave the facility with the animal. If it is identified as a service animal after those questions are asked, if it's out of control and there's no action taken to resolve the situation, if it's not housebroken, and if it's not harness leashed or tethered in a way, unless there's a specific action that they do that the disability requires them not to be, then they can be asked to leave the restaurant or the business, excuse me. What about allergies? So under the ADA, allergies, fear of dogs, these are not generally valid reasons to deny access or refuse service. So in this context as well, we can't discriminate, we can't isolate people. There can't be any fees charged, even if there's fees for other animals in certain businesses. This has to be bypassed when it comes to a service dog. Next slide, please. So just some things to watch out for when we're talking about customers or patrons. There's no doctor's note that makes this a valid service animal just because your doctor says so. Again, it really comes down to that test that they are trained to perform to assist somebody with their disability. That's really going to be the key here. And further, there's no license or certification. As you can see here pictured, there's websites, there's different things that people unfortunately pay money to get these licenses, these certifications. But legally speaking, they have no standard, no bearing. So just because someone has a license, if they can't answer those questions, then you can make that call to remove them from the premises. And if doing so, it is worth mentioning, that patron, that customer still has the right to whatever services or goods that you offer. So they do have to be given the opportunity to get whatever that may be without their animal present. So just the last disclaimer here, we kind of have to take the customer's answers at face value. If they answers those questions in the affirmative, that's going to be, what we have to move forward with. Next slide. So now we're going to shift gears a little bit and turn to employees and staff. So the same rules don't apply here because we're in a different title of the ADA now. And under this title, Title I, as an employer, we have to provide reasonable accommodations to folks with disabilities. So, this can be any change to the hiring process. This can be a change to the job, the way the job's done, the work environment. And these are going to allow people with disabilities who are qualified to perform those essential functions of the job to perform that job. And the difference here, between Title III and Title I is Title I is going to apply to service dogs and emotional support animals. So it all comes back to that reasonable accommodation requirement that we have under the ADA. And what is reasonable? It really is job specific. It kind of depends on the way the disability affects the work, the environment in which the work is taking place. And unless there's some kind of direct threat or an undue hardship, it usually is going to be something that's granted, especially in the aspect of a service dog. And, kind of an example, if you can imagine like a bank teller, we have a service animal that might help somebody with a certain disability walk and move around. That's going to be, probably a reasonable request for a position like that wouldn't have undue hardship attached to it. Where if we work in a scientific lab that has to have certain standards of cleanliness, that might be an undue hardship to let an animal in. But again, these are very specific to the type of business that we're running. So these inquiries have to be taken very seriously and analyzed on a case by case basis. Next slide, please. So the process here is known as the interactive process, and it's really a back and forth, a communicative process where the employer and the employees are going to work together and kind of assess whether the disability has the ability to be reasonably accommodated through the use of an animal. And it's not an automatic right, but again, it has to be taken seriously. It has to be well documented. And, the first step is the employees or a third party. It can be a family member, it can be a doctor, is going to request the accommodation for that animal. And, this should provide enough information to put the employer on notice and kind of give them some sense of what the medical condition might be. But there is really no, method required. And a big red flag is that employers should not, condition an accommodation on the completion of a certain form or any type of paperwork that the employer provides. So after this request comes in, we're going to analyze the eligibility here, reviewing the request for the accommodation, taking all the factors of the job into consideration, looking at the link between that medical condition and the request and the task that is going to be performed, and kind of taking a deeper dive into, is this something that is considered a disability under the ADA, and kind of going through those analyzing steps there. Next slide. So step three, we're going to engage in, an informal process. This is a discussion, a back and forth, some clarifying needs, and, identifying whether, the animal use is a reasonable accommodation, or if there might be other accommodations that we might be able to explore. You can ask for additional information. This can be in the form, obviously, of medical documentation, but this is only going to be the case if the need is not obvious. For example, somebody who has a seeing eye dog, that's going to be a relatively obvious need in connection to their disability, where PTSD, for example, might not be as obvious from the outside looking in. And those documents that you request, they're kind of going to only be used to establish that the disability is there and that disability requires an accommodation. You can't ask for full medical histories or dive too deep into that document gathering process. And then once they provide it, you can't keep harping the issue. No more additional proof is needed. Once you've established those two aspects of the documentation, then the inquiry for additional documents ends there. Next slide, please. So step four, we've already gathered all the information. We've analyzed the circumstances. You can look for alternatives and then make that decision. So the ADA allows the employer to be the ultimate decision maker in this situation. And when the request comes in for the use of a service animal, you can accept or deny the original request. But again, we want to always document the reasons for doing so. We want to have proof that we thought about this, proof that we went through this process and really did the due diligence here. And then if you're going to deny that request, it's a good idea to provide some alternatives that are going to be effective in allowing the employee to perform that essential function of the job. In cases of service animals, the denial is going to be a bit more rare than it would be in the case of emotional support animals. And we're going to generally expect to grant these, if the disability and the function are related, and one helps the other. The service animal is going to help the employee perform that essential function of the job. The service animal has sufficient training. And again, as long as there's no undue hardship, direct threats, or fundamental alteration to the employer, these are inquiries that are usually going to be granted, and these reasonable accommodations will usually follow. Something just to point out, an undue hardship is not, a small financial investment. We usually see that being reasonable as far as an accommodation is concerned. So again, just to kind of pound this into the presentation here, if it is denied, we really want to come up with alternatives and what can this look like. An emotional support animal, for example, if we feel that that's not going to be a reasonable accommodation based on the work and based on the job, for depression, for example, we might want to offer additional breaks or rooms that are safe spaces that employees can go to and gather themselves. Different things like that. Just offering that alternatives is showing that you're willing to work with the employee and willing to come up with solutions. So third time I'm going to say it, but again, we really want to document each step in this process, document the actions taken, and just really keep a great record of what we've done to take this request seriously. Next slide. So just kind of a wrap up, how to be compliant as the employer here, as far as the employees are concerned. You want to make sure that the managers, responsible employees understand the law, because it bypasses you, and it goes to a direct supervisor, for example. It's important that they do. We want to explain also to the requesting party that there is this difference between, employment and public accommodation rights under the ADA and what those might be. Again, fully engage in the interactive process, take it seriously, make it an open dialogue, a communicative process, and document everything. Again, we don't want to really have policies that are non-flexible, that deny, emotional support animals and have automatic approvals for service animal requests. We want to have clear boundaries and expectations if some of these accommodations do get granted. The employee with the accommodation should know exactly what the do's and don'ts of the accommodation are. And if there are problems, we want to address them quickly and privately, just to avoid any further issue. We want to save this process for after employment, unless a candidate brings it up, and then we would start that process and kind of pre-hire, start to analyze what that might look like and what that accommodation might be. And we want to treat this as a case-by-case basis. Every step in that interactive process I talked about is fact intensive. So we want to look at every case a little bit differently, and that's kind of why these inflexible policies might not work for the business. And we want to treat these like any other requests for disability accommodations, and again, take that process seriously and do what we can to make the job reasonable and enjoyable for the employee while keeping the best interests of the business at heart as well. So thank you so much, guys. It was a pleasure, and hope to be back soon.
Thank you, David. That topic always is an interesting one. I think we're seeing more and more of it, and there are a few questions in the Q&A. So in the interest of moving things along, I'll just have you take a look at those, as we move on to Laura's presentation. With some good questions there, so thank you everyone for participating. Next topic here, we have Laura Harshbarger, who is a member in our Syracuse office in the Labor and Employment Department. In fact, the chair of our Labor and Employment practice here at Bond. So honored to have you here, Laura. Really important topic since it takes effect tomorrow. So you're here to help us figure out what we need to be ready for starting tomorrow. So thanks so much.
Thank you, Kristen. Good afternoon, everyone. So we're going to talk about some amendments to New York's breast milk expression law. We have a law on the books. I mean, there's something from a federal standpoint, and then we already have a New York State law. But New York State has amended, updated, and really expanded its paid breast milk expression requirements. And so we're going to get into that now. Next slide, Cappy. So you find this at New York State Labor Law 206C. It applies to all public and private employers of all sizes, and it provides for both break time as well as specifications about the location that an employer needs to have available to an employee who has a need to express breast milk while at work. So none of this is new. The statute has applied to public and private employers. It has provided for break time, and it has specified certain physical arrangements in the workplace for breast milk expression. Next slide. So the change is primarily one of whether or not this break time must be paid or unpaid. So up to this point in time, the law has provided for 20 minutes of unpaid time for breast milk expression. And that was understood to be up to once every 3 hours. So it was 20 minutes of unpaid time. But as of tomorrow, amendments take effect that require an employer to provide 30 minutes of paid time. This was part of the budget process. And so, as of a couple of months ago, springtime, April-ish, we were aware that this would be a new requirement. What wasn't clear in the reading of the statute, it was whether or not this was one allotment of 30 minutes of paid time over the course of a day or the employee's shift, or whether this was 30 minutes of paid time every time that an employee might need to express breast milk. The guidance that has just been posted within the past 24 hours or so in advance of the implementation date of tomorrow, makes very clear that it is 30 minutes as many times as is needed. Certainly that's the Department of Labor's understanding of the law. So in a notice that we'll talk about in a moment, the notice from the Department of Labor says, you, speaking to employees in New York State, are entitled to as many 30-minute paid breaks as you need. The guidance makes clear that it is an individualized analysis to the employee in terms of how many breaks are needed during a given time at work. Again, pointing to the notice, this is a notice to employees. Your employer must accommodate you whenever you reasonably need to take a break. The number of breaks needed throughout the day will be unique to each individual employee. There is no maximum in the law. The law speaks to kind of reasonably, right? You reasonably need to take a break, but there is no maximum. And frankly, there is no indication as to how an employer would go about determining what's reasonable, when isn't reasonable. This is clearly something that is left largely, if not exclusively, up to the employee. Employees may take additional unpaid break time beyond the 30 minutes. So 30 minutes is not a cutoff. If the employee's need for breast milk expression goes beyond that, the time then is unpaid. The employee's other break time, so paid meal breaks or other unpaid breaks, may not be diminished. And again, this is from a notice. As an employer, you cannot deduct paid break time for breast milk expression from the employee's regular paid break or meal time. The paid time for breast milk expression is in addition to any regularly paid break or meal time. Employees can also choose to take breast milk expression breaks right before or after their regularly scheduled paid break or meal periods. Furthermore, an employee cannot be required to make up the lost time. So if we've gone into unpaid break time, the employer can't say, oh, because you weren't paid for so many minutes during the shift, you need to stay overtime. Employer cannot say, well, look, you took 3 paid breaks to express breast milk. That was 1.5 hours of paid time. I need you to make that up at the end of the day. That is not possible. Next slide, please. The law also creates notice requirements. So we have to provide all employees, and I note that it does say all employees. It does not say female employees or female identifying employees. The law says all employees of breast milk expression rights at 3 different times: the time of hire, annually, and upon a return from maternity leave. As part of the new guidance that is on the website, and we have the link there in the slide for you, the New York State Department of Labor has issued a policy. It's not clear, quite frankly, if this is a model policy or if this is the policy that must be distributed to employees. Certainly, if the Department of Labor is taking the position that it is this exact notice that has to be distributed to employees, it's not really clear that would be substantiated by the law, but there is a statement on the Department of Labor's website that makes one believe that certainly the safest course of action is for employers to use the notice that is on the website. And the reason for that statement is employers are required to tell employees about their rights regarding breast milk expression by providing them the New York State Department of Labor policy on the rights of employees to express breast milk in the workplace. I bolded the New York State Department of Labor policy. That's my bolding, but you see why I've bolded it. It is a definitive statement that the notice that seems to be expected by the Department of Labor is their notice that they have now posted. Next slide. How does an employee invoke these rights? Well, first of all, the employee has these rights for up to 3 years post-birth. The employee must provide the employer written notice through letter, email, text, chat app, or other communication means used by the employer, and then the employer must respond in writing to the request within 5 days. Next slide, please. The lactation space requirements, these are things that did not really change with this law, but just reminding everyone of what they are. It is a dedicated room if possible, if not possible, a temporarily vacant room, or quote unquote, as a last resort, a cubicle with walls at least 7 feet tall. The space may never be a bathroom. And there are various other physical requirements, good artificial or natural light, a chair and a table, or other flat surface must be in the room. If it's a room, it has to have a functional lock. If it is a dedicated room, then it must be, let's say it's a cubicle, then there must be a privacy sign. If there are windows, they have to be covered. There should be an electrical outlet. Assuming that there's electricity, good natural artificial light, as I mentioned, access to a clean water supply, and if there's a refrigerator, employees must be allowed to use the space to store pumped milk. So the big takeaway from today's session is that starting tomorrow, employees are entitled to 30 minutes of paid break time as often as they reasonably need it, as well as additional unpaid break time. And be aware of the new notice requirements. Make sure that we are now incorporating a notice, presumably for right now. Again, the best course of action is the Department of Labor's own notice into your hiring packet and your hiring materials, things that are presented to employees at the time of hire. It does appear to be all employees, and that's just the safest course of action anyway, right? We need not worry about who identifies in a way that may not make it obvious that that is a person who should receive this notice. Additionally, annually, so we'll add that to your list of annual notifications that need to be made. And any time that an employee is returning from maternity leave, so again, that would be a female employee returning from giving birth, there is again an obligation to provide written notice of an employee's rights to express breast milk in the workplace. Thank you.
Hi, Laura. Not surprisingly, there's a bunch of questions. So, I know you'll take a look at them, but just I think we do have some time here. I thought I'd mention a couple. One is if their break ends up being more than 30 minutes, what happens with the other 10 minutes? Is it paid? Can they use it's either unpaid, or can they use other types of paid time?
Correct.
Yeah.
They could. So the law says that an employee may want to take their breast milk expression time, let's say, adjacent to meal time. We can't reduce the meal time. So let's say the employee is a half an hour for lunch, and the employee might say, I'm going to go to lunch early, use that as breast milk expression time, then go right into my 30 paid minutes of lunch time. That would be an hour of paid time as opposed to their usual 30-hour lunch time. If it's I have 30 minutes of paid time to express milk, but I need 45 to complete the process, then the person is paid for 30 minutes and they have 15 minutes of unpaid time.
Yep. And then another question embedded in that one was, well, could they just take a second 30-minute consecutively? I think no. I mean, the language is 30 minutes each time you need it. And there's some chatter in the Q&A about, actually, isn't it that the first break is paid at 30 minutes and the rest are unpaid? And I get where that question's coming, because I believe, and Laura, I think you agree, you can read the law that way. And a week ago, that's how I was reading it, but the FAQs on the Department of Labor's website are very clear that in terms of the Department of Labor and the way they are interpreting it, they're interpreting it every time you need a break to express breast milk. It's a fresh 30 minutes. Right, Laura?
Right.
Yeah. So we all don't think maybe it matches up with the statutory language, but that's what we've got. And then, a good segue into our next presentation deals with the question of exempt versus non-exempt. And we've got Suba here, who's a bit of an expert in that area as well. What about exempt employees? So after those, if it's a 40-minute break for an exempt employee, I mean, I think, what are your thoughts about that?
You're asking me, Kristen?
Anyone,
Yeah, yeah.
or
So-
Suba.
Yeah. So, I mean, I don't think there's a difference because if you're an exempt employee, you're paid for the entire amount of time anyway. And you you can't be required to make up the time. So it's going to functionally look the same, right? The employee is going to be entitled to express breast milk, and there isn't going to be any expectation of additional work because of that, and there isn't going to be any reduction in pay.
There's also a lot of questions about employees who are out on the road. Those are great questions. I'll keep moving along here to Suba's presentation, but certainly if we can answer, we will here, we'll follow up with you, but any of us here at Bond, this often happens with the new law, lots of questions. We're here to assist with these questions, if you want to reach out. Everyone's contact information will be at the end of this presentation. So thanks again, Laura.
Yep, you bet.
Suba, let's talk about travel time, actually. And I didn't even plan it that way, that I mentioned that a lot of the questions are about the, traveling employees and breast milk expression. I won't expect you to deal with that here, but you're going to talk to us about travel time considerations just in terms of the compensability, right? So
exactly, right.
Great. So thank you for being here, and go right ahead.
All right, thanks, Kristen. So yeah, I thought I would spend 10 minutes or so talking about travel time, and I just want to be clear, I'm not covering this topic because there have been any developments in this area, but this is an area that we get a lot of questions about, and it's often misunderstood because some of the rules aren't quite as intuitive as you would think. So I think it's helpful to have kind of a review of when travel time must be paid and when you can decide not to pay it. Next slide, please, Kathy. So the general rule on commuting time is that it's not compensable. If it's just simple home to work travel and then work back to home travel at the end of the day, it's not compensable. There's some complicating factors in terms of, if an employer allows an employee to take a company vehicle home to carry tools, and then the employee is required to report to another work site. And the purpose of the employee taking the vehicle home and transporting the tools is really for the employer's benefit as opposed to the convenience of the employee. That may convert that time where the employee is taking a company vehicle from home directly to a work site for the purpose of transporting the tools. It may convert it to paid time, but the general rule is home to work travel and work back to home travel is not compensable. And that's true whether the employee reports to one work site or whether the conditions of the job require that employee to report to perhaps more than one work site. And this case that's referenced here on the slide, this Kavanaugh versus Grand Union case, which was decided back in 2000 in our Second Circuit Court of Appeals, is kind of a good illustration of that. It's kind of an extreme illustration, but it kind of demonstrates what the terms are for excluding commuting time from compensability. So in that particular case, Kavanaugh, the plaintiff, was a refrigerator mechanic, and he was employed by Grand Union and was responsible for about 50 Grand Union stores all across the Northeast. He lived on Long Island, but he basically got his assignment the night before, and he'd have to travel sometimes up to 3 hours one way to get to the grocery store that he was reporting to, and then travel another 3 hours back to Long Island. And the court said because his conditions of employment were clear at the time that he was hired, that he didn't have a fixed reporting location and would be required to report to several different job sites across a large geographical area. The lower court said that commuting time is not compensable, and the Second Circuit affirmed that and agreed that it's not compensable because that was part of the conditions of his job. So if you have that circumstance where someone's required to report to a variety of different locations, I think it's important to make that clear in writing when the person is offered the job, that one of the conditions of the job is that they report to a variety of different locations and you can specify the geographical area or even specify the particular locations. That should be good enough to exclude that from compensability. The outcome of that case probably would have been different if Kavanaugh had been called outside of his regular work hours. So like 8:30 at night, he gets a call saying there's an emergency at this particular grocery store. You need to go there and fix it. In that circumstance, the FLSA regulations recognize that that time spent traveling between home and work, if it's a substantial distance, is compensable if it's outside of regular work hours. Next slide, please, Kathy. Travel on a special one-day work assignment that does not require an overnight stay is compensable. So, as an example, if you have an employee that's regularly employed in Syracuse but has to go to Buffalo for a special one-day assignment, the employee leaves home at 6 o'clock, starts the assignment at 8:30, leaves Buffalo at 4:30, comes back home at 7. That entire time from 6 a.m. to 7 p.m. is compensable, excluding whatever regular unpaid meal period that you would have otherwise provided to the employee. Next slide, please, Kathy. Within the workday, travel from one job site or customer location to another is always compensable. So, for instance, in the Kavanaugh case, when he traveled to his first job site of the day, that time was not compensable. But once he got to that first grocery store and then reported to another grocery store, the travel from one grocery store to another grocery store was compensable. It is permissible to pay different rates for travel versus regular job duties. So, if you have an employee who makes an exorbitant hourly rate on a construction site but travels from one construction site to another construction site during the course of the day, there's no legal requirement that you pay that travel time at the same rate that you would pay the actual construction duties. Obviously, you need to make sure that you're complying with minimum wage. And if you're paying it at a different rate, you need to be absolutely sure that your records reflect which of the time was travel, which of the time was spent on the construction site. And you also need, if the employee works more than 40 hours in the work week, you need to make sure that the overtime is being computed at time and a half of the blended hourly rate, or 1.5 times the higher hourly rate, instead of just paying the overtime at the rate that's in effect when the overtime is worked. So, if at the end of, if the employee's already worked 40 hours, but then travels from one work site to another, you can't just pay time and a half of the lower hourly rate for travel time. You have to blend the rates and pay the weighted average, time and a half of the weighted average. Next slide, please, Kathy. Out-of-town travel requiring an overnight stay is compensable during any hours that correspond to the employee's regular workday, regardless of whether the travel actually occurs on a regular workday. So if the employee's regular work hours are 9 a.m. to 5 p.m. Monday through Friday, any out-of-town travel that requires an overnight stay that's between 9 a.m. and 5 p.m. on a Saturday or Sunday is still always compensable. And that's true regardless of the mode of travel, regardless of whether the employee is driving himself or whether the employee is just a passenger on a plane, train, or other form of public transport. Next slide, please, Kathy. Out-of-town travel that occurs outside an employee's regular work hours is only compensable if the employee drives. It's not compensable if the employee is a passenger in an airplane, train, bus, or even a car. So if you have two employees who are traveling to the same place for an overnight assignment, and that travel occurs outside of regular hours, regular work hours, you kind of have that paradoxical result of the employee who's driving is required to be paid for the time driving. The employee who's simply a passenger in the car is not required to be paid for that time. So by way of an example, if the employee regularly works in New York City from 9 a.m. to 5 p.m. Monday through Friday, the employee flies from New York City to Raleigh on an 8 a.m. flight on Wednesday and arrives in Raleigh at 10 o'clock a.m. The time from 8 a.m. to 9 a.m. is not compensable because the person is simply a passenger in a plane outside of regular work hours. But the time between 9 a.m. to 10 p.m. or 9 a.m. to 10 a.m. is compensable because that occurs during the employee's regular work hours. Thank you. That's all I have, Kristen.
Okay, thank you so much. Appreciate it. Very practical information. So that's our final presentation for the day. We have some questions that I'm not sure we got to all of them. There are a lot, but we'll take a look at those after the session and connect with you. Here is the contact information for the presenters. If you have any questions, I'm at K Smith, easy enough, at bsk.com. Appreciate everyone's attendance. Also, as I often say, please send us suggestions for topics. We're always looking for your input. Have a good afternoon, everyone.